Welcome to this installment of Trial Tutorials. Today we are covering opening statements. I'm Rudy Lehrer, a member of the Board of Governors of the Beverly Hills Bar Association. I'm delighted to introduce our speaker today, Morgan Chu. Mr. Chu is a partner at Irell and Manella, LLP. He is chair of the firm's litigation practice group. Chambers USA described Mr. Chu as, quote, beyond doubt, the most gifted trial lawyer in the USA. In Peter versus Nanquist, Mr. Chu argued and won a decision, believe it or not, by 9-0 at the U.S. Supreme Court, in which it overturned a Federal Circuit panel decision on appeals by patent applicants. To date, Mr. Chu's results at trial and in settlement have resulted in over $9 billion in actual payments to his clients. That's separate and apart from key defense verdicts, which he has also obtained over his career. Mr. Chu, we are honored to have you here today. Now, a note for our audience, if time permits, Mr. Chu will consider questions at the close of the presentation. Please be sure to list those questions in the Q&A chat. So with that, let's get started, and I'll turn the mic over to you, Mr. Chu. Thank you.
Thank you very much. Good afternoon, everyone. Sally was very excited to be going to school on a bright and sunny day until she got to the crosswalk to her elementary school. And her legs will never be the same. If you're a really gutsy plaintiff's lawyer in this personal injury case, sit down. I want to talk about that sample opening and pick it apart. Notice that it is likely that everyone in the courtroom is looking at Sally's legs. Notice what was not said. There is no mention that Sally will never be able to walk down the aisle when she gets married years later. Notice there is nothing said about the 2 years of reconstructive surgery for her legs. Notice also that there's nothing said about the Ford F-150 that was going 60 miles an hour in a 25-mile-an-hour school zone. It didn't need to be said. Those things did not need to be said to tell a story. So rule number 1 for opening statements is tell a story. Tell a story in a way that people are going to remember it. A good story doesn't have 23 points or 17 or 11 or 9 points. A good story usually has 1 good point. A story is something that jurors can describe to their friends or family after they're done with their jury duty. What was the case about? Their friends would say. From the opening you've just heard, I think it would be relatively easy for every juror to say, oh, it was about Sally, who got hit in the school crosswalk, and her legs were mangled. Notice also what's going to happen next in the trial. The skid marks, the speed of the Ford F-150, the school crossing zone. All of that can be explained by the accident reconstruction expert. None of it needed to be said in the opening statement. Notice also, it was short. How short was it? I'm guessing 30 seconds. How short was it? I counted 2 sentences. And in 2 sentences, there was a story. Now, not every opening statement can be reduced to 2 sentences or 30 seconds. But every good or decent or even fair opening statement ought to be short. So if there's one takeaway from this, make your opening statement short. I didn't always realize that. I used to think, gosh, I was involved in these very complex cases and that I needed a lot of time for opening statement. And then I noticed judges started to say, well, Mr. Chu, how much time you need for opening statement? An hour. An hour? I can read what wrinkled brows look like. And over time, I learned without being required to shorten my opening statement. And some judges now, particularly federal judges in many different states throughout the country, limit opening statements. That's less common in California state courts, less common in state courts throughout the United States, but shorten it yourself. Remember, each minute that ticks by, you run the risk of boring one of the jurors. You don't run that risk in the first 5 minutes, 10 minutes, 15 minutes. You might begin to run that risk as the minutes tick by after that. And to a certainty, you are not only running that risk, but perhaps incurring the wrath of some one or more jurors as you drone on. And as you drone on, people won't remember what's the main point of the story. So the first point is tell a story and make it short. And as you're preparing, think about what you're going to say. A little bit later, we'll talk about how to prepare an opening statement. But however you prepare, make it short and then make it shorter and make it shorter still. How important is opening statement? Some people who write about and teach trial practice say it is the most important aspect of a trial. There's no doubt. It does have essential importance. There are 3 times during the course of a trial that you might get to talk directly to the jurors. One is opening statement, one is closing argument, and usually in state court, you can actively participate in voir dire. In federal court, many judges won't let you ask a single question. Some federal judges will let you ask a few limited questions, but they'll watch you with an eagle eye, making sure you're not conditioning jurors in a way that's considered improper. So think of it as 2 or 2.5 opportunities to speak directly to the jurors. And most of the trial time is going to be consumed by direct examinations, cross-examinations, and maybe examinations in a rebuttal case. This is a precious opportunity. Some who write and teach trial practice say it's the most important opportunity because it's the first time that jurors hear directly what is the case about, and they're hearing from both sides. Psychologists and people who study how we communicate say there is the rule of primacy, what you hear first. And that holds true for the trial at large, and it holds true for opening statements. Before I go on to some other do's and don'ts, let me go to our hypothetical. I hope everyone's had an opportunity to review the hypothetical. But even if you haven't, here's the opening for the plaintiff. Nathan and Jessica are 36 and 33 years old. 2 years ago, they were very happy. They got aboard the Vacations to Go cruise ship. They were celebrating Jessica's birthday. And they were asked by the cruise director to everyone on board, do you want to participate in a belly flop contest? it was a fun thing to do. And, well, Nathan said, okay. And they were all invited to the side of a pool. Hundreds of passengers showed up. And Nathan raised his hand. He signed up. He was going to be 11th out of 14. And there were 10 people belly flopping before him. Some making a big splash, some not making a splash, some barely doing a belly flop. Who practices how to belly flop? Nathan didn't know how to do a belly flop. He wasn't told what to do or what not to do. He was not told what not to do in a pool that at its deepest part was 4 feet deep. He was not told, don't dive into the pool. And not knowing how to do a belly flop, not receiving any instructions on what a belly flop is. He did what many people do naturally when they are diving into a pool. He dove in and he hit his head and he suffered serious acute spinal injuries. Now I'll be defense counsel. Well, what Mr. Chu didn't tell you was that there were signs, 5 of them in total, that warned passengers about the rules for each of the swimming pools on the cruise ship. And it included a rule, no diving. Mr. Chu also didn't tell you that along the side of the pool, there were markers every 3 feet that said what the depth of the pool was. 4 feet, 4 feet, 4 feet, and circling the pool. And Mr. Chu didn't tell you that in addition, there was a warning that had the icon of someone diving into the pool with a red circle and slash against it. There was a warning, number 1, from the 5 signs. There was a warning about the depth of the pool. And there was a warning not to dive. That's what he didn't tell you. Now I'm going to stop. Being plaintiff's lawyer for Nathan and Jessica, I did not do one of the cardinal rules for anyone, whether you're representing the plaintiff and speaking first or representing the defendant and speaking second. And that is to anticipate your weaknesses and bring them out. And therefore, I handed my adversary, he's a pretty good lawyer. He kind of looks like me, but he's on the defense side. I handed him a gift because he could begin his opening with a drum beat of what Mr. Chu did not tell you. And immediately he has undermined the plaintiff's lawyer's credibility at the very beginning of the trial. If I could rewind, being plaintiff's lawyer, I would have pointed out that with the hundreds of people there, who could see those 4-foot markers? Because the crowd was right next to the pool. Who could see those signs on the pavement that said no diving because it was crowded with hundreds of people? Who could read to stop the signs by the entrances to the pool, where at line 17 it said no diving, and before no diving It said no ice cream, no food, no alcohol, no this, no that. But it would have been 1 minute to anticipate one of the key weaknesses. Note also, I didn't go through all of the facts that dealt with what the defendant might point to in the case. That perhaps Nathan did not follow what would be recommended in terms of medical procedures. That could be left to another point in time. And that defense point that the injuries might not have been as severe if Nathan had gone through a different course of treatment sounds not so good as a defense. And therefore, I did not need to anticipate it. My opening for the plaintiff in the hypothetical, it was relatively short, more than 2 sentences, but not too long, I don't think. And the defense could add to what defense counsel said, but on the defense side, I wouldn't go on too long because defense counsel in my hypothetical had undermined what was taking place. So let me go to some do's and don'ts about opening statement. The first is tell a story. No matter what kind of case it is, tell a story. Tell a story that anyone from the street could understand. Tell a story that you can torture, if you have a 10-year-old at home, torture your 10-year-old or 12-year-old, torture your spouse, torture staff at your law firm, torture some of your fellow lawyers, and see if you can tell a story in 3 minutes or so, and just ask the simple question, what's this case about? See if people can not just tell you they understood the story, but tell you what the themes are for your side of the case. Although I've already said it, make the opening short, edit it, and make it shorter. Let me go to some don'ts. Don't start with excuses. Don't start with overly long introductions. What's an excuse? I'm not as good as the other lawyer. Her case is very easy to explain. I'm sorry I'll have to take 3 hours of your time to describe the case. Another excuse that you should avoid is stating a rule of law such as opening statement is not evidence. Think about what that says to jurors. It says, well, don't listen to me. Every juror, whether they have been called to jury duty or not in the past, knows that they're supposed to decide the case on the evidence. There have probably been preliminary instructions that have said exactly that. And if any point in opening statement, a lawyer says, opening statement is not evidence, that's another way of saying, Mr. or Ms. Juror, feel free to tune me out right now. The next don't is probably going to be hard for some more junior lawyers or lawyers who have done 10 opening statements or more. Don't read your opening statement. Notice I didn't say for preparation, don't write out your opening statement. Some people find it easier to write out their opening statement in full. Nothing wrong with that. But if you do that, try to shorten it to something you can fit on an index card, or at least one sheet of 8.5 by 11 paper. And if you can fit it on one piece of 8.5 by 11 paper, see if you can reduce it to a series of bullet points that will remind you of the key points. And even if you need to have that sheet of paper in front of you or the index card, you will be prevented from reading it. There's a judge who was on the Southern District of New York. He's now on the Second Circuit, and he tells this wonderful story. He spent a number of years as an assistant U.S. attorney in the Southern District of New York. And there's this very well-known lawyer who was working as an assistant U.S. attorney, and a younger lawyer was doing his first opening statement. He prepared for it. And the senior lawyer looks at him and says, "Hey, you look prepared. This is the morning of opening statement. You got a dark suit on. You got a nice bow tie. You look like you're ready. Are you ready?" "Yep, I'm ready." "And you've got your opening statement figured out?" "Yep, I've got it right here." And the senior lawyer sees, oh, he's showing me many pages of what he has written out for his opening statement. And the senior lawyer says, "Well, let me see that." And he takes the 15 pages and goes, rips it all up and throws it in the trash can. Now, I'm not wishing that on anyone. The junior lawyer did just fine because he knew the case well enough. He didn't need the crutch of the pages, and he didn't need to read the opening statement. The main point is, do not read an opening statement. Another point, do not be too detailed. Not every little twig of evidence needs to be highlighted. You can tell that from my opening about Sally. There'll be many important pieces. They're not just twigs, they're branches on a tree, but there's no need to highlight them during the course of opening statement. Being too detailed also has the disability of making your opening statement more complicated, harder to follow, and longer. Now, I'm going to go to another don't, because this is the basic rule of opening statement in every court, state and federal, in the United States. Do not argue. The rule is you're supposed to state the facts. You're not supposed to argue. An argument might be, you can't believe anything that 10-year-old Sally could say. She doesn't have much of a memory of the accident. Well, it's a bad argument, but it's an argument nevertheless. The strike zone here is very difficult to define. You think baseball umpires sometimes have a tough time with strike zones, particularly in the era before we have video replays and can see exactly what a strike zone is. But judges have very different strike zones. For some, it's very small, and any tinge of an argument, they may chastise counsel. If you happen to be in the situation where opposing counsel may object, or the judge on her own says, "Counsel, you're arguing," you step back and say, "Yes, Your Honor," with a smile, and say, "The evidence will show," because that little phrase is a way to say, "I'm just talking about the facts." So keep that in your tool chest to help you out. Now let's go to some of the maybes. One big maybe is if your case has some technology of some kind that's out of the realm that an ordinary person off the street would know, you might want to teach a little bit about it. But try to do it in a simple way that will make people understand what the case will be focused upon. I have a lot of cases that are very heavy in terms of technology. They involve designs, as an example, for semiconductor chips. The designs can be very complicated or difficult to understand. To get better performance by executing instructions from the firmware that's on the chip out of order. You can tell that jumble of words doesn't sound like it's going to be easy for anyone to understand. But people do understand the following, that engineers, scientists, and ordinary consumers prefer faster chips. That ordinary consumers prefer chips that save power, meaning they give the consumer longer battery life. So if you are going to explain some technology, find a framework that everyone on the jury can understand. You don't necessarily have to discuss and educate the jurors about the technology. It's a maybe, but if you do, keep it simple. Second, maybe use visual aids. What I see more and more in just about every kind of presentation, including opening statements, is that the presenter uses this big crutch. It's easy to use, and it's called PowerPoint. It's slides, or it's boards with a bunch of words on it. An effective opening can use 0 visual aids. You notice I didn't use any visual aids in doing an opening for Sally or for Nathan and Jessica. That crutch of using visual aids can be very, very effective. But it can also be counterproductive. First of all, once you start showing jurors slide 1, 2, 18, 23, and so on, they are no longer looking at you. They are looking at the board. So it's hard for you to establish visual contact, eye contact with the jurors. Second, if the jury has seen 23 slides or 64 slides, it's more difficult for them to remember what was the important point or what were the 3 most important points. Consider using 0 slides. If you want to use slides, recognizing that you might be using them as a crutch for yourself to remember the points you want to make, well, your little 3x5 index card is much better for those purposes. Another point about visual aids. Most of the time, they're not very good. Most of the time, they're really bad. They're too complicated. They have too many words. I have, for all the lawyers in my firm, what they will say, and you can ask anyone at Irell and Manella who's been involved in our trial practice currently or in the past many years, what's Morgan's rule about visual aids and PowerPoints for trial. I have a rule. It's a simple rule. I call it the billboard rule. What's the billboard rule? You're driving down the street anywhere in Los Angeles, and you're going to see a billboard. And you've got about 3 seconds to drive safely and understand what the billboard means. Some very effective billboards you might remember. Apple had a billboard that had one word on it: think. Every billboard is designed for the viewer who's going to look at it for 3 seconds. You can't have more than 25 words. Better to have 4 words, 3 words, 1 word, maybe 0 words, but a limited number of words. Better to have a graphic, and better that the billboard make 1 point, not 3 points. That's the billboard rule. Now, when you get in your car later today or tomorrow, driving down the street, you'll look at billboards a little differently for the next day or two and ask yourself for each billboard, do you get the point? If you do, it's at least an okay billboard. Is the billboard memorable in terms of the point? Well, it gets a higher grade. If you see too many words on the billboard, it should get a failing grade. So visual aids are fine. Don't use too many. And if you use them, use the billboard rule. The visual aids, although they can be extremely effective, are not very effective at some things. Let me give you an example. I had a case where we wanted to demonstrate how much $30 billion is. And if you think about it, I didn't know. And as I asked other people in my firm, nobody really knew what $1 billion is. That sounds odd. We can all figure out there should be, if it's one comma, and a series of zeros. Yes, we can figure that out. But what does $1 billion, much less $30 billion, mean? And we had some graphics consultants. We had a lot of people on the trial team. Everyone had their ideas. And most of the ideas revolved around taking currency, $20 bills, $100 bills, whatever it is, and having them wrap around the globe. Well, how many times around the globe do you have to go to get to $1 billion? Or having those dollars laid end to end to go to the moon, or maybe it's to the moon and back. But as I thought about it, I said, this doesn't get people thinking how much $1 billion or $30 billion is. It just shows an interesting graphic. Another alternative is to show dollar bills stacked up high. So instead, I decided for opening to use words with no graphics. And here's what I said. How much is $30 billion? It's very difficult for me or most people in this courtroom to understand what $30 billion is. But let's suppose you're lucky in life and you're earning $30,000 a year and you don't have to spend a penny of it on rent, on gas, on groceries. You don't even have to pay taxes. And every year you can take the $30 $100,000 and put it in a savings account. How many years will it take you to get to $30 billion? My pause is intentional. I want people to think about it. They're not looking at a visual. They're asking themselves, how many years? I asked our damages expert that. He took out his fancy calculator. It can do lots of tricks and gymnastics and all kinds of other things. And he punched a bunch of keys and he came up with the wrong answer. And he was off by a lot. Because one of the difficulties of using any kind of calculator is knowing how many places should be before or after the decimal point. What's the answer? How many years to get to $30 billion? 1 million years. And that's a way to think about how to describe something where I think it's more effective to describe it orally and not to use any graphics. Because you could say, well, how many years is a million years? You go back to the year Christ was born, it's a little more than 2,000 years ago, to when the Great Pyramids in Egypt were first constructed, roughly 4,500, 5,000 years ago. It's a tiny, tiny fraction of a million years ago. A maybe is describing expert testimony. Some cases may boil down to a battle of experts. Not all, but some cases may be just that. So if that is the case, if you can think forward to jury deliberations, and what will the jurors, assuming half are favorable for the plaintiff and half favorable to the defendant, what will they be debating? They may be debating the expert witnesses for each side. And if you think that's a real possibility, you may decide that you should describe expert testimony. But don't toss out the other rules. Be short, make a point, hopefully 1 point, not 7 points. And then ask yourself, if I fairly describe in opening what each expert will say, why should the jurors be favorable to my side of the case? And if it's not a clear answer, maybe you need to rethink some of the themes of your case. A fourth point about a maybe is damages. Some people, plaintiff or defendants, they don't discuss the amount of damages. And I used to think that way, particularly if I was on the plaintiff side asking for a very large amount of damages. And then defense counsel would say, what Mr. Chu didn't tell you is he is asking, he's going to be asking at the end of this case for $1 billion, or in some cases more than that, for the people he represents. So here's a happy medium to consider. It may not apply to every case. Let jurors know, or consider letting jurors know, if you're representing the plaintiff, the magnitude of the case in terms of damages. And by that, I do not mean that you have to put a dollar sign in their mind and say, well, this case is worth billions of dollars. because that will come as a shock. Most people say, well, how can that be? Or maybe even with a personal injury case, someone of modest means whose injuries were not catastrophic may be asking for 3 million. And to some people, that will seem like a lot of money because they've already heard about or heard something about what the physical injuries are. Let me give you an example of a way to describe basic facts about damages. This is a patent infringement case. The defendant infringed. It didn't infringe once or 1,000 times. It infringed 15 million times by making 15 million infringing chips and selling for several $100s each 15 million chips. So I didn't put a number on it, but I put some brackets. Some people may do some simple calculations in their mind. Everyone will come away thinking, oh, this is a case that by order of magnitude involves a lot in the way of damages. Here's another maybe, and it depends upon the case. Leave some surprisingly good evidence to be presented first through witnesses. Make it a surprise. Make it a surprise for people. Make it a pleasant surprise. Make it a kind of surprise that will enhance your credibility. I'll come to another maybe in a little bit. I do see that there are some questions. I'm going to go to some questions, and I encourage people to go online to ask questions. One question: what are your thoughts about opening statements for a bench trial? Oh, I think that's easy. I came to the remarkable conclusion that the person sitting on the bench is a human being, and they're like the jurors. Well, they are the juror. It might be a single juror for the facts, but you want to whet their appetite. And all the rules for a jury trial apply to a bench trial. If you've had a trial brief, I still would apply all the rules. The rules include tell a story, make it a compelling story, make it a set of facts that will compel the finder of fact to rule in your favor. Let me use this as an opportunity to mention, because you might want to read about this, going back many years ago, there are a couple of social scientists who did what are called the Chicago jury studies. And they published numerous articles about those Chicago jury studies. Some people interpret those studies to mean that the opening statement is the most important part of the trial because a huge percentage, 85% of jurors, make up their mind because of what they hear at opening statement. In actuality, pundits who wrote about the Chicago studies were creating something that was not directly said by those who conducted the studies. But what is true is the following. If both sides follow the basic rules, that is, describe the facts of the case, and both sides do a decent job of describing the best facts for their side, it is unremarkable that most people hearing the best of the facts from both sides, will conclude who ought to win, or at least tentatively come to that conclusion. Another question: how often do you make your opening longer versus shorter as a result of mock jury trial results? It is almost always shorter for just about every case we have. We do one or more mock jury trials. And it's not to predict the outcome. It's to test certain themes for both sides. Mock jurors don't know who's doing the presentations, don't know who's paying them to show up for the mock jury. And some potential themes for the side we're on just don't resonate. And if we were thinking of playing to some of those themes in opening, we're no longer going to do it. So often it makes opening shorter. Sometimes it does not have an impact, but it makes sense that it would often be shorter. Here's another question: how does your strategy change for a bench trial such as family law? I've not done family law. I have found that recently judges have preferred waiving them altogether. I have heard that. I have had colleagues who've gone on the bench in LA Superior Court, and they often have had family law matters, and at least one still has family law matters as their assignment. And the judges are processing a lot of cases, which is why the judge may say, well, I don't need to hear opening. And why many lawyers say, okay. If I was practicing family law, I think I could think of something important to say in 3 minutes or less. Do you do a detailed postmortem on the case you have lost? If so, what have you discovered from a general principle point of view? Well, we try and do, and I try and do, a postmortem on every case, win or lose, and sometimes cases aren't so clear. Now, the recent World Series was in doubt. It was in doubt after the 5th game, after the 6th game, after the first 9 innings or 8.5 innings of the last game. But it's always worth doing a postmortem. And there are many cases where there are claims and there are counterclaims or cross claims. And so it's not a clear-cut winner, as was the case with the Dodgers. So that's something to keep in mind. But I don't wait to the end of a case. I am always doing a re-examination, such as at the end of opening statement. Oh, by hindsight, what should I have done? How should we adjust our trial presentation going forward? And as the testimony of witnesses unfold, those of you who've had one trial or 30 trials know stuff happens. And particularly when stuff happens, it's always a good time to reassess. So that can be after opening, the first witness, second witness, and so forth. Another good question here is, how often should you address the law and maybe its elements in the opening statement? Remember the basic rule: you can't discuss the law, but you can discuss the underlying facts. let's assume it was a personal injury case and comparative negligence applies. In my Sally hypothetical going to school, I don't think anyone is going to suggest that Sally was at all at fault. Even if she jumped into the crosswalk, if the Ford F-150 was going slow enough, it could have braked to a halt. So there was no need to discuss anything about comparative negligence. Maybe a simple statement, but not in the Sally case, saying Sally was not at fault. That went without saying. Or it might be a contract case. And we all know there needs to be offer acceptance, there needs to be consideration, and other elements need to be met. And stating in a clear-cut fashion, Jake made an offer to buy a bushel of apples. Elizabeth said, sold at X price. They had a contract. Now, I just mentioned two basic elements for a breach of contract claim. Boy, all of these questions are terrific. Here's another one. Do the same general rules apply to closing statements, being short, lack of slides, or other visual aids? Well, the same basic rules apply. Not being overly long, but closing can be longer. And I wouldn't describe it as lack of slides. I would describe it as being judicious, not having slide after slide after slide and only slides. In fact, visual aids can be somewhat more powerful for closing. You can take what a witness actually said, and you can say, remember when Jim Buchanan was on the stand? He said, Humpty Dumpty fell and was crushed. And you can put the words up on the slide. Maybe it's better to use a graphic. Maybe it's better just to use, if you have daily transcripts from the trial, part of the trial transcript. I think it would be rare not to use any visual aids during closing. Let's take my Sally example. I didn't use any, but showing the crosswalk to her school, maybe the skid marks that were testified to by the accident reconstruction expert, and a few other things would be quite memorable. Well, could I give an example of the shortest opening statement you gave and how long or short it was it? Let me broaden it to not only opening statement, but in complicated motions. And one example was a case, this was in the Southern District of New York. There was a lot at issue. There was some great complications. It had to do with the position of West Publishing, that the pagination in its reporters was subject to copyright protection. And it had brought a dozen or more suits successfully in trial courts and had singular success or a string of successes in the appellate courts. And we were representing a New York-based publisher, Matthew Bender, and we wanted to attack that where across the board West Publishing had been successful. The court had reserved all morning for the argument. The other side went on for an hour and 3/4 and then finally sat down. I got up and said the following. West Publishing is claiming a copyright protection in 1, 2, 3, and other page numbers. The claim is staggering. And I sat down. I haven't done a 2-sentence opening or closing, but I have done some openings with few minutes, few words, and a limited number of sentences. Let's see, another example. Oh, how do you stay sharp? That can mean a lot of different things. And do you see yourself as getting sharper and sharper with age? Oh, that suggests that I'm aging. Well, people ask those questions or similar questions. And I would say for everyone who's participating in this program, everyone in the audience, we all recognize that past a certain age, some would say past age 18, someone else might say past age 23 or 29. They can't quite do the same things they did before. Maybe if they run a tad slower, or they lift weights, it's a tad more difficult to lift a certain amount of weights. So there is an interesting thing, and I'll say it in a very positive way, that I truly believe. One of the great things about being a lawyer is that, unlike just about everything else in life, whatever other profession or avocation you chose, most lawyers, in fact, get better with age. Now, I wouldn't say that's the case with terrific brain surgeons, because their physical skills may decay. And you certainly wouldn't say that for pro football players and many other people. But we get smarter and wiser. We learn how to avoid mistakes. We learn how to anticipate. We don't throw away what we learn every day. We add it to our stores of knowledge. And I would liken it to the following. I'll use an example. I think it was Peyton Manning, and he was at the top of the game as he grew older and older chronologically. And he was a championship quarterback. And people would ask him, well, how do you do it? You're obviously not as fast. You're not as quick physically. He said, yeah, I know that. Of course I know that. But I see every play unfold in slow motion. And over the years, I began to know that I could spot where my first receiver, my second receiver, my third receiver was, and at the same time, I could determine who's rushing, who's not rushing, whether they're doing something else in terms of their defense, whether they made a shift in their defense. Everything is unfolding more slowly. So lawyers, we're like decent bottles of wine, and unlike the best of wines, we get better and better over time. Would love to know if there's a story behind the spam pen holder. Well, yeah, there is something that's case related, but I hadn't had spam in many years. COVID came around, there was a feared meat shortage because some meat packing plants had to be closed. So my wife Helen and I, when we were at Costco, when we could go to Costco during COVID, I said, well, let's buy some canned meat of some kind. So, of course, at Costco, you can't buy one can of Spam. So I bought whatever the size of the packaging was. I said, yeah, I hadn't had Spam in a long time. This tastes pretty darn good. And Spam and cheese on an English muffin is terrific. Slices of Spam on a salad. It has limitless possibilities, including when I was in Japan very recently. I went into a convenience store, and one of the items they had in the refrigerator was Spam sushi, which tasted great. It tasted great. Now, in addition, the can comes, I'd say, free of charge, and is great for holding all kinds of things, not just pens and pencils, but I found it very useful as a pen and pencil holder as well. I want to thank all of you for joining this program. And one last thought for everyone: have fun. Have fun practicing law for the rest of your lives. Thank you.